killed me.
Okay. Good evening. It's Thursday, September 25th, 2025, 7 p.m. This is a special Common Council meeting in the City of Franklin. Madam Clerk, would you please take the roll?
Mayor Nelson.
Here.
Alderman Pecorelli.
Here.
Alderwoman Eichman.
Here.
Alderman Asana is excused. Alderwoman Day.
Here.
Alderman Salus.
Here.
Alderman Craig.
Here. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we are going to go now next to citizen comment period. This meeting, there's the agenda that's been put out, is to go over some things with some late legal issues, legal bindings that we've come upon. We up here, and I'll speak for only myself, but we are crystal clear on where citizens stand. We are split as a community in some areas, but we are hyper aware of where people are on this and why they're where they're at and where the school's position is and where the people are supporting that side. So we're crystal clear on it. We would like to move this forward as quickly as we can, but we had to have this meeting as part of due process and as part of how we would move forward to Plan Commission, how we'd move forward. That way, we had to have this meeting tonight. So with that said, I'll open citizen comment period, and it'll be the normal same rules about repetitious, 3-minute maximum. Again, we've heard many of you speak at these meetings. We respect it. We appreciate it. We've taken note. We know where people stand in this. And then we will then, once that concludes, we'll discuss this under reports and recommendations. We will be looking to go into a closed session to discuss some things regarding legalities and legal, and then we'll come out and we'll give an update. So that's the basis how this will go down tonight. So with that said, citizen comment period is open. Anybody wishing to speak? Again, we've heard many, many times where you're at, so we understand it, we appreciate it, and we respect everybody's viewpoints. 3 minutes max, name and address at the podium. Now we're going to close it and move on.
This is Judith Williams-Kalaki, 4901 West Forrestal Avenue. I know you've heard me multiple times on the subject. I'm trying to not be duplicative of what I've already said, but I wanted to point out a few things. First of all, I thought Franklin had a policy of not reconsidering issues for at least a year. Maybe that's changed, but now we are here a second time within a month for this council to discuss a resolution that they just passed a month ago. And after there were numerous meetings on this topic, nothing has changed regarding this project since you voted initially or since you reconsidered last week. In fact, I want to point out that the issue on the agenda is a motion to rescind and amend. The agenda does not indicate that this council is taking action to reconsider its actual decision. As such, I am assuming any rescission and amendments will simply be to further support the initial decision made by the council, since no vote to reconsider that decision has been noticed. Now, if the council is actually considering changing that decision on the conditional use permits, there are a few things that should be considered. I don't know if you'll go into closed session, but if you do, I would ask that you think about these things. First of all, the council has substantial evidence to not grant the conditional use permit. First of all, I have not heard anything about the DNR permits. Maybe somebody else here has, but I don't even know whether those have been granted. I don't think the ones that have been filed are consistent with what has been presented to this council. I would also point out that the resolution, which was already passed and which the board has decided not to reconsider, is supported by the school's unwillingness to perform a traffic study. It was talked about at the Common Council meeting. It was talked about the planning decision meeting. For whatever reason, the school district has decided not to do that study, and that failure should be held against them. If you were to reconsider issuing the conditional use permit, you should at least require a study, because you're talking about putting a lot of people into a small residential neighborhood. The last time I was here, I suggested that somebody go over and look at what the school looks like at a pickup time on 4901 where I live at 4901 West Forest Hill Avenue. I don't know if anybody did that. It is a complete and absolute zoo. So I would ask that that be done. Finally, I would also ask that if the council changes its decision on the conditional use permit, that it also reconsider the conservation easement changes, because you did that vote after you did the conditional use permit. And I'm assuming that people in this room thought that conditional use permit was going to be in effect when they approved changes to the conservation easement. That's all I have.
Billy Prochnow, 8229 South 47th Street. Announcing an unscheduled common council meeting with less than 24 hours notice gives the appearance of trying to move something forward without adequate public input. Holding such a meeting behind closed doors only adds to that concern. I would like to know why the high school is being allowed to continue delaying progress and threatening lawsuits simply because they dislike the outcome of votes already made by both the Common Council and the Planning Commission. I would also like clarification on whether taxpayer money is being used to fund the attorney that they have hired to threaten the city. To date, Dr. Bennon and Mr. Cromie have made little effort to engage meaningfully with the public. Instead, they appear focused on advancing their own agenda, regardless of community concerns or costs. These plans could have been revised weeks ago, and construction could already be underway had collaboration taken place. It is both reasonable and responsible to keep Highview Drive limited to emergency access only, adding approximately 140 additional vehicle trips daily, 70 in the morning and 70 in the afternoon, through a residential neighborhood is unnecessary and poses safety risks. Vehicles already enter from the front without issue, and the existing design could be reworked to allow staff to reach the back parking lot in the same way it is done at the middle school. I urge the Common Council not to yield to the threat of litigation from the school. The original decisions of the council should be upheld. Thank you.
Thank you, ma'am. In response to that, Madam Clerk, could you please confirm when this meeting was posted? The 7 p.m. meeting was posted yesterday?
It was posted within the 24-hour period, so it was posted at about 6:30.
Thank you.
So it was
outside of the 24 hours.
outside the 24 hours.
Well, I understand, folks, but okay, I'm gonna address this because I have to. So, I understand there's this, well, please let me respond, because this isn't about cynicism. We had a meeting with the school yesterday. We had to act after that meeting to where we're at to tonight. So we had to have all these documents done, prepared, and make sure that the council members could appear. And that took time. And so when the meeting ends, so we could have did it maybe an hour earlier, but it was posted and it was more than a 24-hour notice. And that's what we had to do. And there was a reason why we had to. I do not like emergency meetings at all. I do not like having to go into closed session at all. But these are things that we have to get done, or it's only going to get much worse. And this is pretty much the last kick at the cat, so we're going to give it a shot. And that's why this meeting was called. So we will resume citizen comment period, and then we're going to try to move this along. Please.
Nicole Schlacks, 8213 South 47th Street. Good evening. I want to begin by thanking you for your continued efforts to listen to myself and my neighbors again and again, for seriously considering our concerns, posing important questions, and voting in ways that allow the school to move forward with their project while still doing your best to protect the residents who live here. Your work does not go unnoticed. That is why I stand here tonight with deep frustration that this issue has once again been brought back for reconsideration. The question of opening Highview Drive for more than emergency access has already been voted on. It was then asked to be reconsidered. Council did not even move it forward for a second vote. And now at an emergency meeting called late last night, or at 6:30, we are being asked to revisit this issue yet again. I find this not only disrespectful to neighbors who have spoken out repeatedly, but also to the Common Council itself, which have voted fairly. It has been said and commented on before that opening Highview Drive beyond emergency access creates risks. These are real concerns that affect families every single day. I trust that the Common Council and the city attorney are working within their legal and lawful limitations to make decisions in the best interest of the entire Franklin community, not just to serve the school's changing demands that stray from the framework of what the original referendum entailed. The original referendum did not mention Highview Drive in it. However, we as neighbors can see why emergency access only is needed. It is your duty to protect residents from unsafe and unnecessary changes, and I trust that you will not bend to the repeated pressure to approve something that is dangerous to the surrounding neighborhoods. I am concerned that the school will not rest until it gets everything it wants, pushing reconsideration after reconsideration while seeking to operate without the proper checks and balances that come from this council's votes and amendments. It is troubling to hear that litigation has been raised months into this process by the school. To me, this is not only unnecessary, but deeply disrespectful to the qualifications of this council and the city attorney. You have acted within the legal framework and in the best interest of the community, and threats of legal action should not override the integrity of your work. I urge you tonight to once again vote no on this reconsideration and to vote no on entering closed session. The people of Franklin deserve transparency, and the neighbors who live here deserve your protection. Please continue to stand firm, uphold your prior decision, and ensure Highview Drive remains for emergency access only. Thank you so much.
Thank you, ma'am. Good evening. Welcome.
Diane Ketchkowski, 10623 Beacon Hill Court West. I feel a lot of the decisions regarding this whole project have been based on personal feelings and connections with a small group of Franklin residents. Your decision needs to be made on facts and requirements. I will say it again, when you live by a school, you should reasonably expect noise and traffic. Every other school in this district is in a neighborhood. They have traffic. Why shouldn't 47th Street have traffic? Why do they get to be treated differently than any other neighborhood in Franklin? I think it's gone on too long. It simply makes no logical sense to make Highview emergency access only. I think you need to reconsider it, make an unbiased decision, revote, and make Highview Drive a secured access, not emergency only. Thank you.
Good evening. Welcome.
Jan Yeager, 7916 South 47th Street. I spoke at this meeting once before. I wasn't able to make the second meeting. I wrote a letter. I called my alderman twice, who hasn't returned my calls, because I heard through the grapevine that this was being considered. Found out about the meeting a couple hours ago. Just came from my exercise class, so you get what you get. People said what I was going to say today, but the thing that I want to add is, I don't have a problem with the noise. I love the kids. We had kids that went to school there, they graduated, they're doing well. I don't have a problem with improving schools. What I have a problem with is taking a residential neighborhood and making it a free-for-all. I live on the corner of 47th and Drexel, and since school started, and this isn't unusual, especially since our community has grown, we've got cars racing down 47th Street already. And if you don't believe me, I invite you to come and sit on my porch someday.
Have you called the police? Okay.
And what I'm trying to say is,
Let me ask you this. Is this before school and after school both times?
yes, but
I will follow up with the chief of police
but
tomorrow.
mostly after school,
Okay?
okay?
I will follow up with the chief of police
And
tomorrow.
they're racing around. Now, that had occurred before, but it's more. There's probably more kids that have cars now as, time goes on. People provide cars for their kids because they move out further out. We're growing. I get that. But if you open that up for anything other than non-emergency, which I was perfect. I thought that was great compromise. It's going to be crazy. And it's not just going to be 5 days a week. There's activities going on. You can't tell me that these parents are not going to want to wait on the roundabout and they're going to look for any way, because they already go around. They're going to look for any short way to just get out of there and get out of the mess. And it's, besides our property values, it's not safe. It's not safe for the families that live there, and I don't have little kids anymore, but there's plenty of people in my neighborhood that do. And it's where we live. It's our neighborhood. And the comment about other schools have, you know, we already are by Drexel. We're already close to 51st Street, so we're dealing with some of that. We're dealing with the stadium. That's okay. But you're talking about grade schools. Those kids aren't driving. Their parents are driving, and they take buses. It's totally different. So that's all I have to say. I hope you reconsider it and stick with your original vote. And we felt that this is a democracy, and it was a compromise, and that was great. And for our aldermen, please answer your calls. I've called you twice about this problem, and I got no return call. I would have appreciated that. Thank you.
Thank you, ma'am.
Chris Piper, 8121 South 47th Street. My main concern, I know all the schools have traffic. It's busy, it's crazy. None of them have high school drivers. When 51st Street was closed, I don't know how long ago that was, but 47th Street became the main raceway. I have little kids. I don't want them getting hit. I don't want a high schooler having to live with the idea of they hit a kid. A lot different than parents. The middle school is also a zoo at pickup, and I get that. That is parents who should hopefully be more experienced. So the idea of having all of that extra traffic seems extremely dangerous. I can try my best to keep my kid out of the road, but as you can see, I can't keep him in a seat here to have a meeting. So I don't want to put that on a high school kid. They aren't the best drivers yet, and 47th Street does become a raceway. So I just, for the safety of everybody involved, would like that to be emergency only.
Thank you, sir.
Ethan Schlax, 8213 South 47th Street. I'd like to just begin by reading off the actual text from the referendum that was voted on in November. I'll just skip to the improvements to the high school that were listed. It lists a technical education space improvements, classroom and special education areas, science lab improvements, new indoor physical education spaces and a field house, a pool, and tennis courts. There's no mention of Highview Drive access being put through. There's no mention of a soccer field being placed in the protected woods. There's no mention of the extra parking lots. And while I understand that once these referendums pass and you go through the planning and there are things that are going to come up, one of which being the emergency access need to the east side of the school. I understand those things need to be put in place. I think all of us do, which is why we requested that it remain emergency access only. I think by opening up that street to anything other than emergency access becomes a self-imposed issue that the district is creating, even though that need isn't actually there. I have a lot of faith in this council. You guys have listened to us, have heard our concerns, and brought these questions forward, and we do appreciate that. I know you guys aren't out here violating state statute, putting forward motions and amendments that violate state statute, especially in front of the city attorney. I would imagine if there was anything that was legally questionable, that would have been addressed at that time, and that hasn't happened yet. So I have faith in what you're doing is completely legal, it is completely right, and we do appreciate the work that you guys are doing. Thank you.
Thank you, sir.
Good evening. My name is Ben McCanna. I live at 8064 South 47th Street. I've lived there since 1994. I am here tonight to talk about the racetrack that 47th Street has become. I will make this short and to the point. Since the time that I lived here, I witnessed a rollover, a car jumping the curb, taking out a couple mailboxes, and just last Halloween, my sister, who was handicapped, along with her grandson, came within inches of being clipped by a speeder. This is a daily occurrence that they fly up and down 47th Street, which is a straightaway from Forest Hill to Drexel. I, along with my neighbors, have called the police, and all they do is put out a radar pole, and within days, it's gone. Now, with Highview going in, be opening up, the school traffic will get worse. We either need a stop sign at both Valley Drive and Highview, and to the extreme to put speed bumps out there. It works in Milwaukee. This might sound a little extreme, but it is necessary. So please do not wait until a child or anyone else gets hit by a car before you take action. Well, thank you for listening, and please give this some serious thought. This has been going on way too long.
Thank you, sir. I like the speed bumps. I like that.
Hi, my name is Rachel Sweet. I'm on 7917 South 47th Street. I am literally on the corner of 47th and Drexel, and I moved into Franklin when I was pregnant with my first child, which has been 15 years ago. And I've seen the development of the way Drexel has changed. When we first moved in, there was no IKEA, there was not a ramp. And since that's changed through the 15 years I've been there, I've seen so many things happen. My neighbor just got his mailbox hit for the 4th time. The police were there last week. Saw women get rear-ended about earlier this summer. Constantly things are happening on that corner, and bringing more traffic and more student drivers, inexperienced drivers, is a huge mistake. I'm worried about my safety of my children and everybody else in my neighborhood. I see the little people and I'm very concerned for them. I think you guys need to seriously think about it. Think about the safety of our youth and keeping our neighborhood a neighborhood. I don't want it to be a raceway or a track. I've seen so many people speeding down that road, and it's really scary. So please consider not letting this happen. Put up a gate, put up a Knox box, do something to keep it safe. I'm all for speed bumps, but something needs to change. Thank you.
Thank you, ma'am. I like the speed bump. Good evening, welcome.
Good evening, Brenda Peterson, 8255 South 47th Street. So I'd like to thank everybody for their consideration. I'd like to thank my neighbors, my fellow neighbors, for speaking out. I agree with the first speaker tonight that if there's going to be a reconsideration on the emergency access, that then there also must be a reconsideration for the Conservancy Agreement. I'm reading from the Comprehensive Master Plan of the city, chapter 3, page 3-2. The city of Franklin has a long history of natural resource protection. Most of the city's prior planning studies listed in chapter 2 address the importance of natural resource protection. The 1992 Comprehensive Master Plan, subsequent amendments in 2004, state the protection of the city's remaining natural resources is an important objective. More recently, the South 27th Street Corridor Plan of 2004 identified specific areas to be presented within the corridor. During the planning area kickoff meetings in 2005, residents expressed concerns about natural resource loss and considered environmental protection to be a high priority. Important principles, goals, and objectives pertaining to natural resource protection, as well as to the lesser extent agriculture and the cultural resource protections, are included in Chapter 2. These same resource protections concepts have been included within other planning documents previously prepared by the city and other organizations. It is intended that the principles, goals, and objectives as set forth below guide the recommendations and suggestions of this chapter. So we've been reasonable. There hasn't been discussions with the mayor and the neighbors. I feel like at times we are being listened to just respond and not listen to listen. I want to stress highly that this is an important issue, and it feels like it's being rushed through, and it was tried to put through the summer when people weren't paying attention. We're paying attention, and we will continue to pay attention. Thank you.
Thank you, ma'am. Okay, so you're seeing, okay. Please, folks, if you want to speak, and then also come in behind the lines, because we really got to move this.
My name is Judy Lair, 4588 West Valley Drive. I don't public speak, okay? I wrote this up. I'm just going to read it. We've discussed this issue with the Planning Commission, the Common Council, multiple times. The school doesn't get what they want, so they keep calling meetings last minute to try to pass their agenda. When the Highview entrance really be an emergency entrance, is Highview wide enough for a fire truck to get in there if need be? Has a study been done on the safety? If this the safety of the children, have we looked into the ways that someone could get into the school? Could they get in easier if you have the full access on Highview, or escape easier off the Highview exit? Our subdivision is a hardworking people who like to enjoy the serenity of our neighborhoods without construction workers multiple times a day for 3 years. After the construction is completed, 70 teachers come in, 70 teachers leave. It is a subdivision street. I walk that street every day with my dogs. I have to cross 47th Street to walk on the sidewalk. So all these cars coming in and out, oh, well, an old lady gets killed while she's walking her dogs. We built there 30 years ago. The high school was there 30 years ago. We listened to the football games. We listened to the soccer games. That we watched the fireworks from our house at the homecoming games. We listened to the band practice. We listened to the band competition this past weekend that ran late. Did anybody call and complain? No, not at all. We are expecting that because we live there. We're not expecting it to be 51st Street. We're not expecting cars to be coming in and out, construction vehicles coming in and out for 3 years. I'm going to point out too that when I do my walk, I walk past the high school every day. The north side parking lot right by the baseball diamond, there's no students parking there. So as far as holding up the construction of the high school, can the construction workers park in that area, seeing all those spaces are open? Secondly, I'm very disappointed and frustrated with some of the Franklin residents. We've been here over 30 years. I've been told that we should move if we don't like the added traffic coming in. I don't appreciate that. My kids have gone to school here, they've graduated, have had nothing but good things to say about Franklin. But now to be told by people that don't like us speaking out against this to move, I think that is very bold.
3 minutes, ma'am.
That was 3 minutes? I practiced this at home.
Well, you went astray. You gave us additional stuff.
Okay, I got one more thing.
Well,
I mentioned it
please.
before to you guys when we had the meeting on 47th Street about the traffic and pickup. 47th Street, from 47th Street to Anita on Forest Hill is parking on both sides. They start parking there an hour before school lets out. I actually took a picture because I was coming home. You go around that curve, there's room for one car. It's like playing chicken as you're driving in your subdivision. There's cars parked on 51st Street. There's cars
345.
There's cars parked on the
I
subdivision.
don't want to shut
across
you
the
down,
street.
ma'am.
I just want that looked into also. As long as I've got my one time talking.
Hi, Jennifer Metzger, 7977 South 47th Street. I'll try to be brief. Once again, thank you for taking the time to listen to our comments. I know it's kind of like beating the dead horse, but we feel the same way. It's like beating the same dead horse. Common Council, Planning Commission, meetings. It's already been decided. It's already been voted. The school district, sour grapes, they don't like what they heard. So instead of coming up with an alternative plan like they were asked to do, threatening litigation to sue the city it just doesn't make any sense. So I would just encourage you guys to stick with what you've already done. I would invite anyone on this council or anyone who's making these decisions to come to our neighborhood. We would be happy to meet with anyone, answer questions, walk you through the wooded area, look at what Highview looks like today. What would it look like in the future? Come and, sit on our front drive at 3 o'clock or 2:40 or whatever. It is a problem. We as a group don't have a problem with tennis courts. We don't have a problem with getting the kids what they need. It's really a safety concern when it comes to Highview. We're all for emergency access. I get it. You got to get cops and firefighters back there in the event of, God forbid, there's an emergency for construction or those kids. We got to get in there. We don't have a problem with the emergency access. It's the extended access. It's the school district always kind of asking for more and wanting what they want and not willing to compromise with the greater good of the actual community. People think it's just this neighborhood, but it really is the whole community of Franklin that we're looking out for.
Thank you, ma'am. Good evening, sir.
Damian Lair, 4588 West Valley Drive. I just want to go on record and reiterate the comments that were made earlier, that this is ridiculous. We're here again for the same thing over. I understand you want to rush it along and we're wasting your time, but you're wasting my time to have to come down here and repeat this over and over again. I'll keep it short, reiterating all the rest of the comments.
Thank you, sir. Seeing no one else coming forward, close citizen comment period. Moving forward to item C as in Charles, reports and recommendations, rescind and amendment to a resolution imposing conditions and restrictions for the approval of a conditional use for the Franklin High School and educational facility use upon property located at 8222 South 51st Street, tax key number 807-9999001, Franklin Public Schools applicant, property owner. In continuation of the process for which a public hearing was held before the Plan Commission on August 21st, 2025. The Common Council may enter into closed session pursuant to Wisconsin State Statutes 19.85 sub 1 sub G as in George to confer with legal counsel for the Common Council who is rendering advice concerning strategy to be adopted by the body with respect to litigation upon the conditional use for the Franklin High School approval in which the city is likely to become involved, and to re-enter open session at the same place thereafter to act on such matters discussed therein as it deems appropriate. Is there a motion to go into closed session to discuss what was just read?
I'll make the motion to go into closed.
We got a first?
I'll second.
We have a first and a second. This will be a roll call, please, Madam Clerk.
Alderman Pecorelli?
Aye.
Alderwoman Eichman?
Aye.
Alderwoman Day?
Absolutely not.
Alderman Salus?
No.
Alderman Craig?
No. Okay, motion to go into closed fails. 3 ayes, or 2 ayes, 3 noes. So, Mr. City Attorney, you got the floor.
Proper procedure pursuant to the statute cited in this special council meeting agenda item and read by the mayor makes it essentially necessary to discuss this in closed session. The school district said they will be commencing litigation, and that deadline is prior to a plan commission meeting. So that would occur anyway, but any resolution of this subject matter which affects the entire city of Franklin and its residents and children and their parents should be resolved, but I'm not recommending discussion thereof in open session. Because ultimately, hypothetically, any debate on this subject matter will simply just add more evidence to arguments to be made by either the school district or the residents on 47th Street and Forest Hill Avenue.
Well, I have
Alderwoman Day?
I have two things to say. First of all, the lawsuit threat doesn't make sense because they're going to sue on items that only the Plan Commission can look at before the Plan Commission meeting. So that doesn't make sense. And also, if we follow Robert's rules, the way the action sheet was written, and the first person that spoke tonight was absolutely right, to a motion that failed cannot be rescinded as it was never adopted. So we're not actually doing anything. If we rescind and go back, basically we're at ground zero where we haven't approved a GD thing. So, okay, fine, we can do that. We'll just go backwards even further. The lawsuit doesn't make sense. They're not going to pull the trigger because if we do this tonight, they're even worse off than they are right now. But if the city attorney doesn't have the cojones to talk about anything or give us any legal advice tonight, then I say, no, it's not out of order. There have been several meetings and several very key legal things that we have not gotten representation on by our counsel. So if we're not getting counsel tonight and we're not going to talk about it, then I make a motion to just be done. My motion is to basically leave things as they are and adjourn for the evening. There's nothing to vote on.
I second.
Mayor,
Well, hold on.
that wasn't a motion to second.
So we've got a motion. I want to make, Mr. City Attorney will chime in first before Alderwoman move into your motion. So Mr. City Attorney, if you want to comment on that first, then we'll.
With regard to your comment on Robert's rules and rescinding, it is not to rescind a motion which was not made. It is to rescind the motion which adopted the resolution at the September 2nd Common Council, which is what it states. And with regard to legal advice, I was not involved in the preparation of this at all until it came to meetings. And amongst all the other matters that I was working on and involved in presentations thereon, this subject matter, all of a sudden issues arise, and that's when the city attorney got involved.
Back to Alderwoman Day again. So if you want to restate your motion, or are you looking to have some discussion or dialogue at this point?
The motion is if we're not going to get legal advice because we're not enclosed or any direction, nothing has been provided to me or the council members that I've seen in this packet or any other communication that refutes any of the arguments that we had last week about this. The criteria for approval was not met for this. There's been no additional proof submitted by the school district. Having a random consultant talk about how many cars may theoretically attend a tennis meet is not proof of anything, of whether or not this is causing a substantial detriment or undue burden on the residential community. Nothing has been met. No new information has been given outside of the fact of another threat at a lawsuit. There's nothing that we have done that is outside the requirements that we have followed for decades that are in our municipal ordinances. So if we did something wrong, then every conditional use we have ever approved is wrong. And if it was wrong, this is now, I think, the 6th meeting we're talking about the same thing, and it's never been brought up before. So either it was right all the time, and now we're just scared of a lawsuit, or it was wrong all the time, and then that's an even bigger issue. But I will also say that this is a horrible precedent to set, that if any developer doesn't agree with a decision that this body makes, that they threaten a lawsuit and the city just says, yep, okay, do whatever you want. I don't think so. So absent of being able to get any sort of advice or proof that what we did was wrong, there's nothing to discuss. So my motion is to basically keep things the way they are. I don't have articulate verbiage for that, but my motion is to continue as it is, and if there's a lawsuit, there's a lawsuit.
Okay, Mr. City Attorney, well, I understand that's music to some ears. I get that. But before we get to that point, Mr. City Attorney, then we're going to go around. Everyone wants to comment before we go for a second, please, Alderwoman.
With regard to your statement about how conditional uses, which the city, up until the recent Unified Development Ordinance Amendment, named them special uses, that was, the law was substantially changed. You said decades and decades, substantially changed in 2017. And I remain in the position that it would be improper on behalf of the city to discuss details specifically as to whether the city did something wrong in open session when in writing and verbally to me as well as to other members of the city government have been told this litigation is forthcoming, period. It's not proper.
All right. With that said, before the second, so you got a first, I understand that, and Mr. Salus, you seconded it.
Yes.
But we do have further discussion, and I know there's others that wish to speak up here. So, Mr. Craig, did you want to start, or I'm going to go over to Alderman?
Alderwoman Eichman has been waiting incredibly
Oh, I know.
patiently.
Alderwoman Eichman, and then Mr. Pecorelli? No? Then Alderman Craig.
Thank you, Mayor. Mayor, I feel it's in the best interest for all residents within the entire city, when we're facing litigation, for this to be held in closed session. I feel it's very distasteful to not listen to legal counsel. As far as I'm aware, there's one person only up here with a law degree. I feel it's in the best interest to protect our taxpayer money on both sides, those who are for the project and against the project, whether it be the residents on 47th and Highview, all residents throughout the city. This is going to be quite a costly lawsuit that we're facing. As one resident who spoke this evening said it very well, it's almost like double taxpayer money is going to be going to this lawsuit. We have pending litigation with the residents, to my understanding. We have pending litigation from the school district. We're looking at the residents of over 36,000 people in the entirety of the city who are already paying for a $145 million referendum. We have seniors that have called me in tears crying that they can no longer afford to stay in their houses in Franklin. So who are we to now bring forth 2 more lawsuits, potentially, by holding this in open, when we could simply hold it in closed? After it's held in closed, then be transparent to all residents and let them know it was decided. We're playing with taxpayer money, and I feel that's not right. I'll yield.
Mr. Craig?
I echo some of the comments of Alderwoman Day of I do not like the idea of setting a precedent that any sort of legal action then makes us capitulate and buckle like a belt. If we make a decision, as you have articulated, Mr. Mayor, that we are up here to make decisions. And that is what we have done in the past, and that's what we will continue to do. My other issue is that if there was something that was done improperly by this body, as far as overstepping our boundaries, then what are we doing here to vote on? Because if putting those restrictions was improper, and I also will add that if someone wanted to bring back the item for the special use permits regarding the lighting, that would be another reasonable item to have discussion about, because that's also part of it. And if anyone wants to take a crack at the natural resource exception again, I'd love to take another crack at that one. I have lots of notes that I would love to add on to it, but we're not doing that right now. So I don't like the idea that if someone, and I'll also be clear, that it is the school district's right, just like it's the residents' right, to file litigation. That's everyone's right to do so. Whether they're standing, whether there's cause, all of that stuff will be adjudicated through the courts, right? And we'll find out. And the entire point of this right now is just to say, we're just going to approve things and not deny them. Because if we deny, well, if all this comes forward, we have discussion and we vote against it, what happens then? Are we still going to go to court again? Probably. So that's where we're at, and we will go through the process because that is how this works. So, thank you.
Thank you. Madam Director of Administration.
Okay. I don't really want to do this, and I really don't want to speak on the matter because of my understanding of the matter and the concerns. However, I do feel like this is something that being discussed in open and not enclosed, it's something that's just going to have to be said. So Wisconsin State Statute 62.23 sub 7 sub DE 1 and 2 requires that a conditional use permit must be granted if the applicant meets all conditions specified in the ordinance or imposed by the city and supported by substantial evidence. That substantial evidence means it's facts, data, and expert testimony. It is not public opinion, speculation, or generalized concerns. It has to be substantial evidence, and that is also the responsibility of the city. So in order to impose conditions upon the conditional use, whatever conditions are imposed must be supported by substantial evidence by this body.
Mr. Salus?
Honestly, I feel that we have been subjected to a campaign of threats and intimidation. We at the Common Council and the Plan Commission, we do our best effort to take care of the issues. We have the public hearings, we have the visit with the neighbors, we listen to this, we debate the issue up and down, left and right. And, we did not make those decisions lightly. After, deliberations and listening to everyone involved, a decision was made. And the same thing here at the council. But for some reason, depends on the applicant, looks like the logic is prevailing here. Might is right. If someone has deep pockets, have a lot of resources, which is our tax dollars, they have the right to bring the issue over and over and over again. Had the applicant anyone else other than the Franklin school system, we would not be here. We would not be listening to this issue for the 6th time. We just like last night we finished the meeting, and here you go, we are here again. We as a community, we have to stand for each other, and we as a council, we have some insurance. If someone want to sue us, let them sue us. We will prevail. We're not doing anything right. All what we're doing is implementing our ordinance. We are protecting our residents. We're making sure that there is no issues down the road. We're looking into all these traffic issues, the potential. Yesterday, I asked a clear question. Is there anyone willing to give me a document, ironclad, that whatever we discuss today, even if we allow the emergency, if we allow certain number of cars to exit from there, is that going to be the end result? Or is it going to be 70 cars today? In fact, it is 150 cars today. Tomorrow, it might be 300. And the day after, it might be who knows what it is. So there is no one sitting around the table managed to say, yeah, I can give you that guarantee. So basically, what are we dealing with? We have a system that basically signed a conservancy to protect the wooded area 10 years ago. Now they're coming around, we say, well, we change our mind. What assurance do I have that the school system will not come 2 years from now and say, you know what, we need a full access to Highview Street? Is there anyone here can give me this assurance so we can consider something and move forward? The answer is no. I yield.
Alderwoman Eichmann, and then we have a first and a second.
Mayor, I just wanted to state, why is every other pending litigation that the city faces, whether it be from a developer or resident, goes into closed session? If I was one of those developers or a tax-paying resident who is threatening litigation against the city and this body goes into closed, will we pick and choose when we want to go into closed? How is that fair? Every other time we're facing litigation, we go into closed. As far as the insurance comment, sure, we've got insurance. Who doesn't? Has anyone taken a look at our insurance claims lately? I have. They're high, and this is going to increase them even higher, which once again will increase the tax base of every resident in this room and throughout the entire city who are already paying on not one, but two school referendums. So by doing this, we are now, as a body, telling every taxpayer in the city of Franklin their taxes will be going up because a few up here want to go to litigation, possibly, and instead of being responsible for what our constituents have elected us to do, is to discuss this in closed session of the pros and the cons of this. That's all we're asking for. I think we owe the taxpayers that. I'll yield.
Madam Director of Administration.
I just wanted to, again, like I said, state I'm not comfortable doing this, but I do feel backed into a corner, and I think that it's necessary, though, to share some factual information on the subject. So the city may impose reasonable conditions, but they must also relate to legitimate land use concerns, not generalized opposition. That state statute that I read before, and I'm not going to read again, it requires substantial evidence, and it requires the condition upon a condition to be grounded in the UDO. So both of those have to be met. You have to provide substantial evidence and evidence of UDO. Adverse ruling, and this is what I wanted to get to, that Alderman Salus had reminded me of a point that I'd like to make as well. An adverse ruling, should this go to litigation? And should this have the end result of not being in favor of the city? An adverse ruling will strip the city of control to impose your conditional use permit, which means that then should a court determine that the conditional use permit should be issued without conditions that have been put on it, then that means that Highview Road would be able to be opened without what the school district has offered, which is a controlled access gate, which is another point of all of this, and that lends itself to compromise. And they've offered compromise.
And the setback.
Well, I'm just taking.
I know, but the
yeah.
60 goes back to 30.
Yep.
So there's a number
Right.
of things here.
So, but the conditions, the conditions, in order to be lawful, they must be reasonable and they must be backed with substantial evidence.
You good? Alderwoman Day.
Thank you. Couple of points. With regard to Alderwoman Eichmann's comment about all the litigation being done in closed session, that's actually not true. About 2 common council sessions ago, we sat here in what I consider to be one of the most uncomfortable situations, more uncomfortable than this, mind you, where we had an actual lawsuit that had already been filed. And there was that person and their attorney, and there were some very, very unprofessional comments being flung around by basically everybody in the room, on the record, on tape, on written down. It was awful. That should have gone to closed. It didn't. I asked the city attorney prior to the meeting, why is this not in closed? And he said, no one said it should be. I was flabbergasted with the things we were discussing. So it doesn't always happen. Should it? Maybe. I don't know, but it doesn't always. And to the Director of Administration, and I say this with all due respect, you're not an attorney.
Right.
So you're stating an opinion that's your opinion, right?
Mm-hmm.
Okay, so you're stating your opinion, which is fine, and your opinion may be correct, but you're not an attorney, and this hasn't been litigated. And so it's your opinion that we have not provided, that substantial proof has to be provided by both the applicant and the city. I asked this question at the last council meeting to the city attorney, and he said that it was the applicant that needed to provide the proof. So there's different answers coming here, and what I'm saying is that I believe this document, the criteria for approval, is a part of the UDO. Is it not? Mr. Martinez?
Come on up, sir, have a seat. Welcome. Take
Good
your
evening,
time.
Planning Manager Martinez. Are you referring to the adequate circulation standard?
The list that developers are given as the criteria, the requirements for the conditional use permit, that list of like
A
7
series of
questions,
standards.
is that a part of the UDO?
Yes, correct.
Okay, so that meets that standard. So again, without, I don't know what we're doing. So I guess there's probably other people that have their hand up, but if not, I'm going to call the question.
Mr. City Attorney?
Second, call the question.
Well, okay, is there a second to the call of the question? If not, we'll go over to Mr. City Attorney. Seeing none, Mr. City Attorney?
With regard to Alderman Salusa's comment about details, number of cars, what assurance, et cetera, is being provided. In the letter from the school district said that they would monitor and continue that monitoring for compliance with it. And that wasn't part of the adopted resolution, but school district could be required to monitor that and provide that information to the city for consistency with any numbers of vehicles approved. And with regard to Alderwoman Day's comments, with regard to the burden overall is on both. Yes, the applicant has to submit evidence, if you will, that of substantial evidence that what's being proposed is in compliance with the requirements in the municipal code, but also the city's decision to approve or deny the permit must be supported by substantial evidence. So I don't term that a burden, but that's the fact pursuant to the code. It's on both sides.
Okay, so Alderwoman, did you want to maybe restate your last question opposed to calling the question, maybe? Would that help
Sure,
things?
would you like me to restate the motion?
Well, not
Or-
the motion, but
okay.
you, so if everybody's good for now, then yes, I would like you to restate your motion, because then we have a first and a second, but I want to make sure we're clear now.
So I guess to make it more clear, I guess my motion would be to receive and place on file the information this evening and not take action on it.
And that's your amended motion?
That'd be my amended motion.
Sir, is that your amended second?
I second.
Okay, any further discussion at this point? Roll call, please, seeing none?
Alderman Craig.
Aye.
Alderman Salus.
Aye.
Alderwoman Day.
Aye.
Alderwoman Eichman.
No.
Alderman Peccarelli.
No.
3 ayes, 2 noes, motion carries. We are, motion to adjourn?
Motion to adjourn.
Second.
All those in favor?
Aye.
Aye.
Any opposed? Let's have it. We are adjourned at 7:58 PM. Please take us.